All right, I just want to talk a moment about something called metadata that comes up. It's been the subject of some discussion. It serves as a good metaphor to talk about some of the ethical issues. First of all, what is it and why do you want metadata? And actually, metadata can be more incriminating. What it is information embedded in the document or in the email. It's kind of behind-the-scenes information. What does it show? The actual time, place, manner the email was created, sent, received, manipulated, or the document, whatever it is. It's sort of a digital footprint of the document. So obviously, like footprints are good pieces of circumstantial evidence, so is the metadata that's contained within the document. What is it? A general definition would just be it's data about data, and that's really what it is. It's data behind the data. It's data about the document content. Generally, it's discoverable because it may contain relevant information to the case. It can be used to authenticate a document. You can use it to prove spoliation, which is an issue we'll talk about in a moment. It can be controlled by the business. Finally, Microsoft Word document. You could get this, and Joe had mentioned this either, but if you send a document and somebody gets it and it's emailed, you can hit the undo button, and then you could see all of the changes that were made, and there may be some embarrassing information in there about information that you put in drafting either the contract or the letter itself or a settlement negotiation offer, things of that nature. In an email it comes up, let's say there you send that email, you want to get information about it. So you'll get information as to who, for instance, received copies of it, proof that the email was even opened, when it was opened, by what computers. You'll often get an issue of someone saying, well, it doesn't prove that I opened it, it just proves that a computer on my desk opened it. But it's good circumstantial evidence, obviously, of what happened. Just a quick story. In New Orleans, there was a politician who was accessing kiddie porn on the internet, and he was saying that it wasn't his, but the metadata showed when that was accessed. So there would be emails to the Boy Scouts, his wife, some other things, then accessing the kiddie porn, then this other stuff. And so at that point, the defense became ridiculous because it would have to have been, well, what happened? You emailed, you went to the restroom, then the guys in the black shirts said, he's in the restroom, let's run in, go on his computer, look at kiddie porn, oh, he's coming back, let's run away and go. So obviously, that probably didn't happen. The court holds in these situations the party should produce the electronic documents with the metadata intact. Now, what's the developing issue? And that is mining for the metadata from another attorney. Our mining lawyers were able to see possible work product and attorney-client information. Kind of like, hey, it's waived, they published it, if you sent it to me and you didn't keep it quiet, it's not my fault that you sent that information. One of the reactions to this has been to call or to declare metadata mining for a document, for the document history, unethical. And so this is the point then that we leave you with to discuss with, or that I'll leave you with to discuss, to think about. And that's the different views on metadata. Is it kind of the thing where we're finding the truth out about a document in e-discovery, and that's what discovery is after all, is finding out information? Or is it the equivalent of digging through someone's trash in an unethical or at least an unsavory way, especially if that person didn't intend to give that information? And with that,